Right. Today's video blog is about why do ship owners always lose misdelivery claims. Now, my previous blog on the anti-suit injunction referred to a case of Times versus NBF. This involved a misdelivery claim by a bank. The problem was, against who was it suing? Was it a demise charter in existence, or was that just a sham to protect owners? The bank brought in rem proceedings in Singapore against the owner and or demise charterer. The bill of lading provided for London arbitration, and the bank commenced arbitration, but against the owner's care of the demise charterer. The demise charterer sought an ASI and then planned to raise the Hague Rules 1-year time bar when eventually arbitration was commenced against it. However, Mrs. Justice Cockerell granted the anti-suit injunction, but only on condition that the demise charterer undertook not to take the time bar in the arbitration commenced against it by the bank. Now, this seems an opportune moment to consider the nature of misdelivery claims and why owners never seem to be able to defend them successfully. We start with the carrier's fundamental obligation under the bill of lading contract to deliver the cargo to the party presenting the bill of lading at the port of discharge and to deliver to no one else. This is an absolute obligation. In practice, it's not so easy to comply with this obligation, as the bill of lading may not reach the receiver before the ship arrives at the discharge port. The solution, as we all know, is for the receiver to take delivery of the goods in return for indemnifying the ship owner. However, if the receiver was not entitled to possession of the goods, the ship owner will face a suit for misdelivery by the party that was. This will usually be a bank financing a sale through a letter of credit. The ship owner will be on its own in facing this liability, as it will not be covered by its P&I club. The indemnity will be enforceable, but that will not affect its initial liability. How then can a ship owner hope to defend a misdelivery claim? They've broken a fundamental contractual obligation, and they've also converted the cargo. Various tacks have been tried over the years. There is the case of the presentation of a perfect forgery of the bill of lading. Ship owners are still liable, even though you could say it's not their fault. That's what was decided in the Motis Exports case. A similar example is MSC versus Glencore from a few years back, where the bill of lading was released to the carrier, who then provided PIN codes for enabling release of the cargo from the container in the port of Antwerp. Predictably, the codes are hacked, and delivery of a valuable cargo of cobalt briquettes is extracted from one of the containers by someone who is not entitled to them. Owners are still held liable. There has been no delivery against presentation of a bill of lading. The provision of PIN codes did not amount to a symbolic delivery of the cargo, and it didn't amount to a delivery order, which was an alternative delivery mechanism provided for in the terms of the bill of lading. Nor will bill of lading exceptions be much help. General exceptions in relation to loss or damage have been held, as in the Motis case, not to cover a loss by the misdelivery of the cargo. There is also the little matter of whether delivery is a carrier's obligation under the Hague and Hague-Visby rules. Mr. Justice Aikens in the MSC Amsterdam was of the view that yes, if the Hague or Hague-Visby rules applied, the package limitation would cover a misdelivery claim. And we have seen in 2018 in the Al-Hani that the 1-year time bar does apply to misdelivery claims. Another line of attack has been to challenge the claimant's title to sue in contract. It has been assumed that when the claimant receives the bill after physical delivery has been made by the carrier, that the bill is a spent bill. And this brings us within section 52C of COGS 92 and also section 22A. So let's have a look at those. First of all, section 52C. In defining a lawful holder, it includes a person with possession of the bill as a result of any transaction by virtue of which he would have become a holder falling within paragraphs A or B, had not the transaction been effected at a time when possession of the bill no longer gave a right, as against the carrier, to possession of the goods to which the bill relates. So that's the first part. And then there is a little exclusion which applies, which is designed to stop trafficking in stale bills. Section 22A, where, when a person becomes the lawful holder of a bill of lading, possession of the bill no longer gives a right, as against the carrier, to possession of the goods to which the bill relates, that person shall not have any right transferred to him by virtue of subsection 1, unless he becomes the holder of the bill, and here's provision A, by virtue of a transaction effected in pursuance of any contractual or other arrangements made before the time when such a right to possession ceased to attach to possession of the bill. In heading A, the word transaction is repeated, and you see it in 52C, but with a further reference to any contractual or other arrangements. And this is really what has been under consideration in most of the cases relating to the ambit of section, the ambit of COGS 92. Most of the cases have actually been to do with the spent bill provisions in 52C and 22A. So, it's been assumed that if you have physical delivery coming before receipt of the bill of lading, that the claimant has to rely on the provisions to do with spent bills. And the big case on this is the Court of Appeal's decision in the Erin Schulter in 2015. Now, the bank received the documents under a letter of credit, queried them, and failed to pay the seller, Gun Law, to whom the letter of credit had been transferred. So instead of sending the documents back, it held on to them, and in doing so it held them as agent of the seller, although it retained them. Subsequently, after the cargo had been physically delivered, it agreed to pay out on the credit and sought to sue the carrier for misdelivery of the cargo. At first instance, Mr. Justice Tier held that the bank, who had received the bill as endorsee, had title to sue as a simple lawful holder under section 52B. But if he were wrong on this, it would have title to sue under section 52C, the spent bill provisions. The Court of Appeal reversed the first of these findings and held that the endorsement to the bank did not constitute it as a lawful holder, as there had been no completion by delivery. Remember, when they received the bill, they hold it as agent for the seller because they are querying matters under the credit, and then they're not paying out. They're holding the bill as agent for the seller. But the bank did become a lawful holder under the spent bill provisions in COGS 92 its subsequent agreement to pay under the credit related back to a transaction which predated the delivery of the cargo, namely the transfer of the letter of credit, and so it fell within section 52C and was outside the exclusion in section 22A. Lord Justice Morbick interpreted the phrase "in pursuance of" very widely. It should be read simply as an ordinary English phrase which should not be encrusted with legal concepts such as real and effective cause, immediate reason, or proximate cause. And those were some of the phrases used by judges in previous cases dealing with section 22A. Scruton interprets this decision as requiring merely that the pre-existing arrangement provides the trigger for the transfer, not that it creates a legal entitlement to the transfer of the bill of lading. Now, quite interestingly, Lord Justice Morbick also observed that actually this is probably not a spent bill case. In deciding what the effect of the transfer to SCB was at paragraph 53, he says, "It was common ground below that by 7 July 2010, when Gunvor accepted payment from SCB, the bill of lading no longer gave a right as against Dorchester to possession of the goods to which it related, because that right had been lost once discharge began on 15 June 2010. In my view, that was not in fact the case, because the rights under the contract of carriage, including the right to obtain delivery of the goods from the carrier, did not cease when the goods were discharged against the letter of indemnity. They remained in existence and were capable of forming the basis of a claim against Dorchester for misdelivery. Nonetheless, the action was fought on the basis I've described, and neither party suggested that we should depart from that concession at this stage. These views were to form the basis of the decision in 2019 in the Singapore High Court, the UU 9202. The bill of lading had not become spent as a document of title when physical delivery to the wrong party took place, nor was it spent contractually. This involves a rejection of Carver's position that contractually the document becomes spent when it is no longer possible to call on the carrier to fulfil its obligation to deliver against production of the original bill. And then the court goes on to say, well, even if we're wrong, under section 52C, the relevant transaction for 22A would either be the antecedent sale contract or the letter of credit, and that would be fine because both of those took place before the actual physical delivery of the cargo. What's the impact of this decision, the UU 9202? If it's followed in subsequent English cases, and I think it will be, I think you have the position that if delivery is made to the person who is actually entitled to possession but they haven't got the bill, they fall under the spent bill provisions. But if you deliver it to the wrong person, the bill of lading holder is an ordinary lawful holder under section 2.1, and you don't involve the spent bill provisions. You're looking at 52A or 52B. Forget about 52C and 22A. Now, there have been two decisions where the carrier has succeeded on the title to sue front, but while winning the contractual battle, they have still ended up losing the war through a non-contractual liability. First, there is the East-West case back in 2003. The bill named the shipper's bank, which was going to act as his agent, as the consignee. The shipper sent the bill of lading to the bank. Alas, that meant that when the bank received it, the bank became a lawful holder, and section 2A says that's what is the case with a consignee. Reverse the polarity in section 2.5 then means that the shipper has lost his contractual rights. Somebody else has become the lawful holder. However, first in negligence in Mr. Justice Thomas's first instance decision, and then through bailment in the Court of Appeal's decision, non-contractual avenues ride to the rescue, and the shipper is able to recover non-contractually from the carrier. Secondly, there's another Singapore High Court decision from 2012 in the Delfina. This focused on the requirement of good faith that attaches to the definition of a lawful holder. A fraud was perpetrated by the holder of an order bill of lading in collusion with the shipowner, and the fraud was on a bank, a Chinese bank. The cargo was delivered without production of a bill of lading. The usual indemnity was given, with a condition that on receipt of the bills, the receiver would surrender them to the shipowner marked accomplished. The bills recorded shipment in March and the cargo was delivered in early April. When the receiver obtained the bills, it did not surrender them to the shipowner, but used them as part of a scam of a fake sale contract in June, under which the bills formed part of the documents submitted to the bank under the letter of credit. The buyer dropped out and the bank then wanted to take delivery of the cargo. Not surprisingly, this was no longer possible. The bank, to whom the bill of ladings had been endorsed, sued the shipowner in contract under the bills and in tort for conspiracy. The contract claim failed because the endorsement was fraudulent in that it was made in breach of the undertaking by the receiver to surrender the bills to the shipowner when they came into its possession. But the shipowner was still liable in tort for the tort of conspiracy. So even though the poor shipowner had been defrauded by the wicked receiver in not having the bills of lading returned to it, it was still liable. It was part of that overall conspiracy, which was directed at the bank. So, slim pickings for a defence to a misdelivery claim. The only one I can think of is the Glyn Mills thing, where defence back, I think about 1885, where if you deliver against production of an original bill of lading, and there's been bills of lading issued in multiple sets of originals, the shipowner will have a defence if it turns out that the holder of another of the bills of lading was actually entitled to possession of the goods. Apart from that, I think it just doesn't seem worth bothering fighting these claims. You may as well just sort of take it on the chin and pay up. Right, that's, I think, the fourth in my talk, a series of lockdown talks. There'll be another one next week. Thank you for your attention. Goodbye.